and I'm not doing a plea to where he can just get out and just do.
Right from the jump, emotions are high and trust is completely shattered. But how do you fix anything when even the judge looks shaken? Buckle up, because this case is only getting wilder and the pressure is about to explode.
So how do we resolve, Judge?
Huh?
So how do we resolve it?
So
One issue, as far as the GPS monitor and all that, they gave him a new device just now. They said it was a charging issue. They put it in, it would charge for 10 minutes, stop charging. He has a brand new monitor just put on this morning.
I got drug test revelation that he's out at 3 in the morning.
Well, no, it's not that he's out. It's that that's when he reconnected it. So but they gave him a brand new device. So and they're saying there was an issue where they changed the device out. And there's not a tamper on it. It just said it was not receiving. It didn't say it was that he was out and about. It said it wasn't receiving, and then it started receiving again. That's the police report that I saw. It's not like they were tracking him other places.
It's here on 3/11/24. GPS device generated a failed to enter alert at 10:15 p.m. At 11:46 through 3:02, GPS device was in no GPS no cell status and was unable to be monitored during the time frame. Client arrived home at 3:01 a.m. on 3/12.
So that's not when I arrived home. That's when it started charging again. Because it's not a geolocation. I mean, as far as I'm understanding, it's a GPS just where he is. It's not.
I'm going to be honest, Your Honor, that would be a question for you.
Oh no, I'm sorry. It's pointed to the client, not to you.
Okay, I was like,
Saying out and that he's out in the middle of the night.
I don't think they're saying that. What they're saying is it's receiving no signal.
Client arrived home at 3:01 a.m. on 3/12.
What was he before that?
Huh?
They don't know where he was before that. He was at home. It just wasn't charging.
You have.
That's the way I'm reading it.
You have the idea of where he is.
So I don't see any notes from the case manager,
So I also have here, the client was also instructed to obtain a portable alcohol testing device, comply with all testing protocols, refrain from alcohol consumption, and comply with all routine equipment service. The defendant failed to provide breath samples, scheduled times, resulting in 13 skips from 2/7/25 to 3/17 of
213 missed tests. That is not just negligence, that is playing legal roulette with your future. At what point does the court finally draw the line and say enough is enough?
So he's still skipping tests. Come up, Mr. Jones. I just don't get it. I truly don't. It's over and over and over. You are still skipping tests. And I don't know what it is and what I need to do to get you to comply with bond conditions. You're still skipping tests. I mean, I have no other choice. I now have to revoke your bond again.
Well, let's do it, please. Let's play it.
This is not the judge's first rodeo, and you can tell she is done playing games. Think this decision will finally snap him out of it, or he just going to keep crashing through warnings like they mean nothing.
I agree with, and I'm okay, but I'm going to tell you now that I want to have him TRS'd immediately to see how it go forward.
Well, Judge,
You know, just all I want you to do is not kill anyone, man. That's all I want. You know, really, I'm not asking for much. You have since day one in our court have repeatedly refused to comply with bond conditions over and over and over. And I'm not doing a plea to where he can just get out and just do. And so you scare me.
So how do we resolve, Judge?
Huh?
So how do we resolve it?
So yeah, I agree with you. I think that the correct thing to do would be probation. But I would like to have him TRS'd while he's in there. And I have a feeling I know what the TRS is going to say. And that's what I would like to do.
Okay. I would request you to set a bond.
Of course.
This is costing me money, Judge. But already costing me is his family money.
So it's okay to just skip tests?
No, it's not. It's a test, but I'm saying it's a stick. I'm just be asleep, but I'm not trying to skip me wrong. I swear to God, stop talking. You don't sure stop.
Okay, And it's literally, the minute it gets out, we have bond vials just over and over and over. Now, what are we in now? Day what?
One day where it's exactly the results.
What do you test positive for?
THC, Suboxone, Oxy, and benzodiazepines.
You tested positive for OxyContin?
Yes, Judge. Presumptively positive. It's been sent to lab for the test.
What I had envisioned, what I think is probably do like a 2-year probation.
110 days behind bars might sound light, but it is a reset. But in plain and simple question is, will it spark real change or just set the stage for another round of the same old cycle?
I want to do like maybe 10 days as a condition. Do an immediate TRS. We'll get it done today, tomorrow, and we'll see what the TRS says. And I'm going to go with what the TRS says. If the TRS says, and I promise you, Dustin, I will do what if the TRS says that IOP, SOP is the proper course, then I'll do it.
Okay.
You know? But if they say residential, I think that that's, I want to follow what the TRS says because I think that that's the proper course.
Something you've taken. Something you've taken as residential.
Then I have a jury waiting right now.
You should have said, I mean, let's try to get a quick.
Yeah, for sure. So do you want to do the probation?
Yeah, let's do probation.
Okay, let's do it. Okay, Blaze, you let me know.
Thanks. On
Jones, probation.
okay. Yeah, I mean I'll do the probation first, so yeah, for TRS.
Okay.
So, probation TRS conditions.
2-year.
Okay.
I want to do 10 days as a condition. That way I can get the TRS done now, immediately, while he's in. And then I'm going to follow whatever the TRS. Are you Dad?
Yes.
How are you?
Fine.
Thank you so much for coming.
Yes. Can I say something?
First, go with Dustin first, because I don't want you to say something that really, just please. Yeah, you guys can talk, and then later on, if it's then.
It looks like they're recommending like the women's residential. Yeah.
That's a good idea.
So the issue, Judge, she needs to be on a probation. She has 2 open PCSs currently.
It's no rush, really. That's probably the appropriate name.
Okay, so her felony court date is March 28th. And the problem is that I just, so she has the old PCS, but she has a new one, and, she's not going to be able to bond out. The felony court did give her bonds, but she's not going to be able to afford those.
And asking for
A trial date. My problem is, Judge, it could take months and months for them to get the lab back on the PCS. Or I can get a
Do they have the
reason.
last name?
I'm sorry, I didn't catch.
Salmon.
Okay. Okay.
Yeah, it's an old case on it, you're right. I didn't realize it's from May of last year.
It does appear that the labs are still pending.
Yeah, is it really going to take that long to get? I mean, how long do you think it'll take? Do we have any? Are the labs back on the first case?
Yes, Judge, I think they are. Because I think they're in connection with this DWI.
Have you evaled it? Are you ready?
I'm ready. I mean, I was ready before she forfeited, so.
The labs are back on the second case.
It's the same case as our case. Yeah, I have no idea how long it will take to get labs back to you. You don't know? Just no idea.
We have an offer in there. It's an old case. We can set it for trial today if that's what you want to do, Judge.
It's not me. It's Connor. I'll do whatever you want. It doesn't matter to me. If you want to set it, I'm fine. If you want a little bit more time, I'm fine with that too.
Yeah,
You tell me. You're in the driver's seat.
I think that, since she has court next Friday, if we can get just a couple week reset, see what happens next Friday, see if they get the labs, and then if not, then we can.
Perhaps have her see how long it'll take.
Yeah, I'm gonna
Ask
reach
someone else.
I'm gonna reach out to the felony attorney and then maybe the prosecutor, see if we can't work out something. Yeah.
That or ask them, hey, how long does it take? If it takes 6 months to get a lab back, I mean, that's unreasonable.
Yeah.
And I'm with you at that point. So,
For the time being, I'll put an eval to do it for us.
For sure. Yeah.
That's good. Thank you, Judge.
For sure. Morning, Mr. Eli. Come on up. How are you? I know you don't want to go through this treatment, right? And I acquiesced to you last time. You asked me, please, I can get it done. Please, don't let me do it. Don't put me in residential. Don't. And I listened. And what happened? No. You caught a felony DWI, not. We put you on probation. A month and a half later, you pick up a felony DWI. So all this, acting. So now, if this doesn't show that residential is the right thing, then I don't know what does. You know, the only thing that we're trying to do is prevent death on our roads. That's the only thing, right? And somehow we have to get through these. Every other way that we've tried just doesn't work. This is the only other thing that we have left at our disposal. So if you want, we can just set it for a hearing, and if they prove to us that you have violated your probation, then we're going to amend your conditions to put you in residential treatment. We can do this any number of ways. We can have a hold-on hearing, or you can just sign the condition. But if they prove to me, that's what's going to happen.
I'm not signing the conditions.
Okay, so set it for a hearing, and then get the probation officer here, and then we'll see. And then they prove to me that you have violated your probation, then I'm going to amend your conditions. I'm not letting you go. Ever. Do you understand? I'm going to keep you until we get this straightened out, one way or the other. Understand? Okay, good. So I'm at your mercy when you want to set it. You want to do a week. We can set it in a week and then just have a hearing. It's just at the mercy of the probation officer, whatever they are best with. Okay? Morning, sir. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Defendant are in a coordinating relationship on 629. Officers were dispatched to a disturbance at a business in Harris County, Texas. The complainant entered the business, and when she exited and walked back to her truck, she observed the defendant there. Complainant believed the defendant had followed her. Complainant said the defendant was intoxicated and started to insult her. Complainant stated the defendant struck her on the left side of her face with a closed fist as she sat down inside of her truck causing pain. Complainant stated she went after defendant as he entered his truck and grabbed his shirt. Complainant stated she was momentarily dragged as she held onto the defendant's vehicle.
So it was a hit to the face, you see?
We have not been able to prove her yet. I will let you know that I was reading through the offense report. I don't know if this was mentioned in intake, but in the offense report, it does look like she was 4 months pregnant at the time, and it was rare, so this may be refiled as a felony. I'm not sure yet.
Mr. Tejada, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. If I find that you're using, I will revoke your bond, put you in jail. I'm going to do everything in my power to protect my public at all costs. Do you understand?
Yes, sir.
You are not to have any contact with the complaining witness in this case, not to be in possession of weapons, and I'm now entering what's called a magistrate order of emergency protection. This is a court order that identifies Ms. Lopez Leiva as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas.
Whatever the transcript says, when family shows up in court, it's usually for support or straight-up damage control. Question is, can this last-minute intervention actually shift the outcome, or is it too little too late?